Hello everyone, this is Rajiv Eskhana from immigration.com, the law office of Rajiv Eskhana PC. This is our bi-weekly community conference call. Anybody is welcome to join in and speak with us. The usual disclaimers apply. As you log into our call, you hear all the disclaimers and what the conditions of this call are. As usual, I will first go over all the questions that have been posted on the forums. And from then on, I'll answer follow-up questions and then all the new questions. All right, first question is from Indian professional that says, look, these are my qualifications. I have a BS degree, 3-year degree, 1-year PG diploma in IT, and 2 years MSc in IT, which I completed in 1 year, and 6 years of experience. So first question is, does the job qualify for EB3 skilled worker or professional? And the job is bachelor's plus 2 years experience. Well, because the job requires a bachelor's degree, it does qualify as a professional. Any job that requires a bachelor's degree qualifies for EB3 as a professional. If a degree is not required or a less than a degree is required, but at least 2 years of experience is required, then the job gets classified as a skilled worker, also under EB3, no difference. Okay. So the tricky question is, do I qualify for the job as it has been drafted? That's a question that's difficult to answer. And my concern would be that this application should have been drafted keeping this very strange interpretation of USCIS in mind. Let me explain to you. Let us say I've got a 3-year bachelor's degree and a 3-year master's degree. Okay? In India, that's a common pattern. Many countries, it's a common pattern. So you've got a 3-year degree in computer science, bachelor's, and then 3 years master's of computer applications. For an EB2, your master's degree, that 3+3 combo, is fine, no problem at all. But for EB2, for EB3, USCIS wants to see 1 degree, 1 integrated 4-year degree. So when you have a breakup, like a 3+3 breakup, they could cause a problem with that. Okay. Same for you. You've got a 3-year bachelor's degree, then 1-year PG diploma, then 2-year MSc. If you were doing an EB2, it should not be a problem, because at the very minimum, BS plus MS combined would be equivalent to a BS. But for EB3 purposes, combination of degrees can be an issue. So I cannot predict, but I see it as a potential issue. So the labor cert perm should have been drafted keeping that in mind. Next question from Sandy. Sandy has her, I assume, H1 stamped, surrendered all the documentation when she left the company. She's just got a visa stamped on her passport, which is an H1B visa. Never traveled to US using this visa. The visa is stamped cancelled without prejudice. Well, first of all, the problem here is because your visa was approved more than 6 years ago, I don't think you qualify for H1 quota exemption anyway. So none of this is relevant because your H1B was stamped in 2003 and it was valid till 2005, more than 6 years ago. So I don't see how you would qualify for an H1B quota exemption. That takes care of that issue without getting into the other questions. So next question is from Mask111. My spouse worked for a software company in India prior to our marriage. They filed an H1B. Isn't this the same question? Are husband and wife asking me the same question? Maybe. Well, her application H1B was approved and stamped in 2003, but she did not enter USA. In 2004, we got married. I was on H1, she came on H4. Now she wants to start working again. Again, the same answer as the one above, if it is not the same husband and wife couple. I don't see how you can use an H1 approved more than 6 years ago to qualify for a quota exemption. I don't think you would be able to. RRNNM123 wants to know, he has an issue or she has an issue with the date of birth, and there's a couple of month difference in the date of birth. So last time when they talked with me, I had advised to get that corrected. So questions are, how will this affect my approved H-1B, approved PERM, approved I-140? This is a difficult decision to make. First of all, PERM you cannot change. Once it has been approved, you cannot go back and change the PERM. So I don't know what to tell you. You need to sit down and figure this out. I'm going to have to take some time. I can't just make a snap judgment on this. What is the best method for you to follow, whether you should do it at the I-485 stage, or if there's another remedy. I can't give you an answer. There are too many details involved and too many documents involved. But corrections should be made, amendments should be made at some point of time, whether it takes a court process, if that is the most convenient thing, courts in India or courts in USA, and get a court decree on this and then follow through with all the amendments. But I believe that clarifying and correcting your date of birth is an important matter. So short answer, I don't know how to approach this. All I know is it needs to be done. Okay. Kumar PR says, currently working on L1B. So he's got his H1B approved effective October 1st. Okay. One thing I don't know is, do you have your change of status approved? So if your H1B was approved with an I-94, you are automatically going to be on H1 status come October 1st. If, however, you left USA and came back on L1 visa after October 1st, you'll be back on L1. Or if you applied for a change of status back to L1, obviously your wife cannot work on L2 as soon as you hit H1. So if you were to go outside USA and come back, and she should go with you, L1, L2 is restored. Okay. So if you get an H1 with a change of status, you have to get back to L1 back through change of status or through re-entering with a visa. Okay. Once the H1B has been approved, and if it is withdrawn after October 1st, you should be exempt from the quota for the next 6 years. Okay. Next question is Immigration Help 2014. My spouse, who's an LPR, filed I-130, got approved. She's also applied for naturalization, going for the interview. She's got a couple of trips more than 6 months and reason for studies. So the questions are, is there any delay in the interview timeline for applicants at Chicago District Office after fingerprints? I don't know. Overall, national times they are shooting for is 6 months. Okay. Chicago District Office, is there something special? I'm not aware of it. I think it's the same as the national times. I would typically have to make some inquiries before I can answer that question, so I don't know it off the top of my head. And we do have a national practice, all 50 states. So, for me to give you an answer about every sub-office within every state would be very difficult off the top of my head. It's more than 6 months that I-130 has been approved. She has not received anything from NVC. The dates are not current. Is there anything we can do to follow this up? You should go ahead and send them an email, see if they have any information for you. That doesn't cost anything, and they are responsive to emails. And they should be able to track her down through your name, last number, first name, last name, social security number, as well as her own first name, last name, and date of birth. She has been asked to provide evidence she did not abandon her residence. This is during her, I guess, her naturalization application. So she's bringing the following things: school records. I guess she was attending school in a foreign country, I'm assuming India. Letter of explanation that she gives on her personal basis: family ties, mortgage statements, bank statements, state issued driver's licenses. Well, that's the only thing I can consider. I think what else can you give to prove that you have not abandoned? Well, another thing you could do is in the personal statement explain that she did not take up any job in the foreign country, because her intention was to come back. Does the Chicago district office allow oath on the same day? This I know. They don't do, I think they don't do same day, but they schedule naturalization interview oaths 2 or 3 times a week. So it shouldn't be delayed too much. In case she gets naturalized, which option is best? Upgrading I-130 with NVC or direct consular filing after being in India? I think NVC might be faster. Double check with the NVC how long would it take for them to upgrade the case to the spouse of an immediate U.S. relative, of a U.S. citizen, spouse of a U.S. citizen. My feeling is it should be quicker with the NVC upgrade. Okay, but I have no empirical data on this. I think that is the way it should be. Next question is WNBX. Somebody came here on a B2 visa, worked illegally. Then they applied for asylum, but then they withdrew the application. They have an order of removal, 5-year bar. 5-year bar is over. Now, if their US citizen son applies, are they barred because of misrepresentation? Well, first of all, where is the misrepresentation? Let's look at that. Illegal work is not misrepresentation. However, if using the B2 visa, you had a preconceived intention either to work in the US for illegally or to stay in US, say forever, that could be a misrepresentation. Withdrawal of asylum application, there's a split in the circuits as far as I know. Different courts have a different opinion about this. Some courts feel that when you withdraw an application, that is indicative of a frivolous application or can be indicative of frivolous application. So really the only thing, it appears to me from your description, that is of major concern is the withdrawal of the asylum application. If there were material misrepresentations in that application, then you can be barred forever, and there is only one waiver available, which may or may not be applicable to your case. So to answer your question, is this a material misrepresentation that you withdrew the asylum application? Maybe, depends upon where it occurred. Will illegally working considered to be a material misrepresentation? The answer is no. That part is not. Okay. Next question is Anug 2901. 22 years of working experience in the IT industry. Valid B1, B2 visa available. I have visited USA alone and with my family, but I have never worked here. I'm also a visiting faculty to MBA schools in India and teaching. So what are the possibilities of immigrating to USA? Teaching options in MBA colleges in USA, definitely. That's an option, H-1B. Explore employment opportunities, again, yes, H-1B. Probably full-time, that would be better. PhD programs in USA, well, that brings you to F1, then OPT, then H1 route. That's also a possibility. My wife can be a teacher again, an H1 option. What is the EB5 option? Well, for EB5 option, you have to commit money, 500,000 or $1 million, depending upon where you invest. And you don't have to show funds availability, you actually have to invest the money. Okay. Some small exemptions like promissory note secured by your real estate, etc. are possible. Does my family get medical insurance with the provisional green card? Well, with the Obamacare, you have to pay into it. It's not automatic. What is the cost of buying medical insurance? I have no idea. Can I still look for employment in USA after I have invested the 500,000? Yes, you can. So let's say you invest the money with a regional trust, an approved investment scheme. Now you're not going to be actively managing that money. So you can, once you get your green card, you can actually start looking for a job. This is a longish topic. I hope you're here on the phone. I can try answering any specific questions, but this is a very vast topic. How may I immigrate to USA? But H1, L1, green card, through investment, these are obvious options that you have already looked at, and even student visa. Info 007. I'm considering moving back to India. Currently on H1B status, 7th year. I-140 has been approved. If I leave the country, what options do I have to retain my priority date? Well, your priority date is yours forever once the I-140 is approved. Okay, so far this is the law. Do I need to inform USCIS prior to moving back? No, you do not. But surrender your I-94 at the airport when you leave USA. If I want to continue to visit USA in the future, can I apply for change of status? You don't have to apply for change of status. You just apply for a visa. Okay, but let me warn you, once you have the history of your I-140 having been approved, consulates can look upon you as a person who might be interested in immigrating to USA. But your response would be, hey, I gave up my green card. Isn't that the ultimate evidence that I don't want to live in USA permanently? So about your daughter, who she's 15-month old, she's a US citizen, got a passport, anything I need to do? I don't see whom you have to inform. I think you may have to, maybe a good idea to inform the US consulate in India. I think they have some kind of a registration process for US citizens who are living long-term in India and other countries. So you may want to look into that. The US consulate in India may have a registration process. It's not required, but it's not a bad idea. I'm planning on sponsoring my brother under I-130. I'm assuming, and Kaz is a US citizen. 3 questions. Can he apply for a student visa once the I-130 has been filed? He can apply, but getting it is going to be difficult. Can he apply for H1 or L1? Yes. H1 or L1 is not subject to the same constraints as tourist visas or student visas, where filing of a green card becomes a problem. H1 or L1 or H2, H4 or L2 also will allow you to have a green card pending while H application or L application is given. How long is the wait? Typically 13, 14 plus years, something like that. It doesn't matter whether you're Pakistan born or somewhere else born. USCIS INS DOLGC. Working on a CAP exempt H1B as a bio instructor in a community college. Received approval for CAP subject H1B as a business analyst. Started October 1st. Can I start working September 15th? No, no. You have to start on October 1st. You could have, if you had filed an amendment or even the CAP H1B as a concurrent H1, although that is a little complicated. I'm not sure I'm analyzing this correctly. If you are on CAP exempt, you can actually start working on CAP case if you do it concurrently. That is correct. But since you didn't do it like that, you have to wait until October 1st. After I start working for CAP subject employer from October 1st, can the CAP exempt employer file I-140? They can, as long as you have the intention of joining them back full-time at some point, and they have the intention of having you back full-time. Because remember, I-140 cannot be for a part-time job. But if the future job is considered to be full-time, that's fine. This is an interesting question. Can I port my PERM priority date? First of all, PERM dates are not portable. Once the I-140 is approved, the fact that your I-140 was approved under biology instructor and you want to port the priority date to a business analyst is no problem. Okay. Next question, how do I change my username for these forums? Ask Monica. Monica at immigration.com. Monica. Next question, Norwich. If a person who's been working in US on H-1B for the past 15 years gets a new job as a director with 7 to 8 people reporting, can we do an EB1 application? I assume you're talking about EB1C, which is international manager or executive. The answer is no. That is a category that is available to only those people who are intra-company transferees. For example, if you are an employee of IBM Denmark and IBM Denmark is moving you to IBM USA, you will do an EB1C and an L1. But if you were hired by IBM USA from Sun Microsystems, never having worked for any of the IBM branches or sister companies or subsidiaries or parent company outside the United States for 1 year, you will not be eligible for EB1C. Okay. Last posted question, and then we'll start on the follow-ups. Last posted question is from Sai 1984. I'm working in India and holding valid H-1B with present employer. I haven't been to USA on this visa yet. There's a consultancy company in USA that can do an H-1B transfer. Okay. I don't have my 797 copy, which is the approval. Is there any alternative way to transfer? Send them a copy of your H-1 visa stamp. They should be able to file the H-1 as a cap exempt H-1 based upon that. We've done this in the past where we did not have the 797 copy. So it's worth trying. And if they have any doubts, they can contact USCIS and ask them. I personally think it can be done. Okay. All right. Let's open the questions. First of all, I only want those questions that are follow-ups on what I have just discussed. So follow-up questions only. No new questions. Press *5 on your phone, please. *5. 1. Okay. Only one follow-up question. Let's get to it. Michigan, go ahead, please. Michigan, go ahead.
Question. This is Info007. This was I posted a question regarding moving back to India. So the question that I had, the follow-up question that I had was, you had mentioned that yes, I can keep my firm and I-140 if I want to use that in the future.
Hang on. Let me interrupt you for a second. You cannot keep your perm and you cannot keep your I-140. All you can keep is your priority date. So if you ever wanted to get your green card, you would have to start all over again from perm with the new company or the same company if you like. But you will carry the priority date of the old case. So you don't keep your perm or your I-140, you keep the priority date. Go ahead, please.
Okay, so I would have to, the company would have to, if I go with the same company, start over, but keep the perm date. Okay.
Let me also add one more thing. If it is the same company, they might be able to keep that I-1. They will be able to keep the I-140, and you can return 1, 2, 3, 4 years later and file your 485 if you come back on H1. As long as the company can justify in good faith, honestly, that they actually had a permanent job for you and the job continued to be available uninterruptedly for the time that you were gone. In other words, the job did not go away. The job was always there. As long as they have that continuity of the offered job, you can continue from the I-140 forward if you are applying through the same company.
If I apply to a different company, then they would have to start over with my H1 and then perm and so on and so forth, right?
That is correct.
Keeping my priority date.
That is correct as well.
Okay. Now, the other question, thank you. The other question that I had was in terms of if I were to visit, come back and visit, then obviously I would have to come back on a visitor visa, which is B1 or B2. For that, do you see any issues
Yes.
with me getting that?
Yes, I did mention that the fact that you had exhibited immigrant intent by filing or having a Form I-140 filed for yourself, U.S. Consulates can take the position that they will not give you a tourist visa since you have exhibited immigrant intent. I would argue the fact that I started the green card and then quit and came back is the ultimate evidence that I don't want to live there. But it's up to the consulate. They may or may not agree in that respect.
Okay. All right.
All right.
So if I were to apply, then I can only apply after going to India, right?
You cannot, yeah, you can do an adjustment or change of status in the United States. But as soon as you step outside USA, you have to go for visa stamping. And tourist visas do not require a prior approval from USCIS. You can just walk into the consulate. So why do a change of status?
Okay, so you're saying just go to the easier way is to go to India and then get the visa there.
If you want to go out and come back sometime later, yes, that's the only way to do it.
Okay.
All right. Good luck.
All right. Thank you so much.
You're welcome.
Thanks.
Okay, guys. Anybody has any questions? New, old, *5, *5, 1, 2, press *5 on your phone. 4 questions. *5, 5 questions. 5 people, 6 people. No problem. We have plenty of time. 6 people with entirely new issues. So I'm going to go in the order you guys called into the conference. The first person, so we have 6 individuals with questions. Let's start with, 1 second. And this is California. California, go ahead, please.
Yeah, hi. Actually, my question was posted in that blog.
Okay.
Forum. The MASK 111. And I asked the same question through an email to your office, and I got a response from your supervisor for the non-immigrant visa section, Anna.
Sure.
And they did say that they contacted USCIS and my spouse should be CAP exempt.
I don't understand how that could be. If her H1 was approved back in 2003, obviously there's something wrong here. Give me 1 second.
This is not a valid menu option.
Suman?
Yes.
Can you have Anna call me on my office line, please?
Yes.
Let me check with Anna.
Okay.
She's in our Stanton office. That doesn't make any sense. Let's wait for her to call in. Yeah, but if you have any other questions in the meantime, go ahead, please.
That's my only thing. Whether she's CAP
Yeah, no,
exempt
that
or not.
doesn't make any sense because her application was approved in 2003. I don't see how she can be CAP exempt.
Okay.
Okay, so something is wrong here. If I don't, she may be out to lunch. If I don't hear from her in the next 30-40 seconds, what I want you to do is just call Anna and ask her to check with me, or just send her an email.
Okay.
1 second, I think she's calling. I have my phone turned off, so I can't.
All right.
Give me 1 second. Hi, Anna.
Okay.
You're on the speakerphone in a community conference call. Very quickly, one of the people who posted a question for us in the forums also asked you that question.
Yes.
And you said you had contacted the USCIS, I guess, for a client, and you shared the same information with them.
Yes.
But I think you may not have complete information, or you may have misunderstood the question. Here's what is the question. The spouse's H1 was approved in 2003. She got her visa stamped, H1 visa stamped, but never entered the United States. Okay? Is she exempt from the quota? I don't think she is, because the H1 was approved more than 6 years ago. Is your understanding different?
No, Rajiv, that was the understanding. We specifically asked the officer
Okay.
if it's outside of the 6 years, if they would be subject to the quota or not, and the officer said no.
They would be subject to the quota or not subject to the quota?
Not subject to the quota.
The officer is wrong. We need to contact USCIS at some other point of time.
Yeah.
I don't see how that can be possible.
All right.
Because the law is quite clear. I'm always willing to learn new things, but I think the officer is wrong. Did you talk with a supervisor, adjudications officer, or the front line?
All right, we'll do.
No, Anna. Did you speak with the frontline officer, adjudications officer, or supervisor?
Rajiv, let me just get that note. Let me make sure who we spoke to.
Yeah, okay. Because this information is incorrect.
Okay, one sec.
Guys, hold on a second. I just want to clarify this issue. It's important enough for everyone.
All right.
So Anna, confirm for me, please. Do you need a couple of minutes, Anna?
Yes, please. Can I get back to you?
Yeah.
Anna, what you do is, my ringer is off, so have one of the other team members just buzz me, just come into knock on my door. I'll pick up your line.
All
Okay?
right, will do. Thank you.
All right. Stay on the phone. Anna is double checking who she talked with, but I'm quite sure this information is incorrect. Okay?
Okay, thank you, sir.
Yeah. So let me go on to Louisiana. Louisiana, go ahead, please.
Hello, Mr. Rajiv. Thank you for taking my call. I've been talking to you for a while in a different conference calls. It's just a follow-up question to those. I got my 140 approved in EB1, and we are filing for H1B renewal in a couple of days, maybe in next 2 days. And my current H1B is a second H1B, which is expiring on 15th of this month. My question is you mentioned last time, once we file before the expiration, we should be okay. But I have this question, USCIS takes at least 2 weeks to produce the receipt for H1B renewal, which will be after 15th of this month. But is it okay, once we have the receipt, FedEx receipt of sending the papers to USCIS, can I use that to be on the payroll with my firm? Do we need to have the USCIS receipt?
There is actually a regulation. I don't know it off the top of my head, but your lawyer should have it. It's a automatic extension. When an H1 or an L1 is filed in a timely manner, you have an automatic extension to continue working for up to 240 days. Nothing more should be required. As long as you have evidence of having timely filed the application, such as a FedEx delivery, your company should be protected. So continuing to work should not be a problem.
Okay.
Okay.
Thank you very much, Mr. Rajiv.
You're welcome. You're welcome. Good luck. Okay. This is another person from California. Go ahead, California. Campbell.
Yeah. Hi, Rajiv.
Yeah.
Yeah, this is Kumar Pia.
Yes, sir.
So my question is, recently I got approved H1 for this year.
Okay.
So currently I'm working on L1B. So visa is already expired. Only the I-94 is valid. So my question is, my wife needs to stop working as soon as I move into H1, or she need to stop working from October 1st?
October 1st, if you have asked for change of status, because the moment your change of status occurs, she falls out of L1. I'm assuming you applied for her H4, have you not? Have you
Sorry?
have you applied for her H4 also or no?
No, I haven't applied for her H4.
Okay, then on October 1st, if you have applied for H1 status, change of status, you will be on H1, she will be out of status.
Okay.
So you need to apply for her H4.
So
You need to apply for her H4 right now.
Yeah.
Right now.
Yeah, because currently she's working, so I'll be taking the H1 at the end of the October. So just wanted to make sure so that she can work in that.
You cannot do that. You cannot do that. October 1st, you are automatically on H1.
Okay. Okay. Yeah. Thank you very much.
You're welcome. Good luck. Okay, let's go to Georgia. Go ahead, Georgia, please.
Hi, Rajiv. I'm a U.S. citizen. I had applied for my parents' green card back in February. The 130 was approved in July, and I just got notification from the National Visa Center for the next step, which is the affidavit of support and the fees associated with it. Once that's completed, it gets sent to the country of origin and to the embassy there. My question was, is it possible at this stage to have them move here and continue the process? Because I've heard it takes another 6 months from here, and you really need them here in the next couple of months.
It's very unlikely that they will be allowed to enter on a tourist visa when the intention is to adjust status. I think it's highly inadvisable to try that.
Okay, so you recommend we shouldn't even try that?
I would not. If it were my own parents, I would not.
Okay. And do you have any idea how long it takes once it gets to the embassy in India? Or is that totally different every year?
It is different from time to time. I would say 6 months is from NVC on to the actual interview usually. Okay. Have you sent the papers back to NVC or no, not yet?
No, I just sent the fees today. And they're supposed to contact me, and then I'll be sending the affidavit of support. So I just started the process with the NVC.
My guess would be it would take 6 to 9 months from now.
Okay, so the whole process can end up taking a year and a half, that means, from the start?
From the start, yes, it can.
Okay.
All right.
All right.
Good luck.
All right, thank you so much.
You're welcome. Okay, let's go to Florida. Florida, go ahead, please. Florida. Florida. Tampa, Florida. Okay. Let's go back to Ventura, East California.
It's 805 number.
Okay. Go ahead, please.
Hello. Yeah. Hello. This is regarding my husband. Okay. He is currently on H1 visa.
Okay.
While he was on H1, he enrolled in a PhD degree in Florida University.
Okay.
And he has completed 92 credits. And he has completed his examination and a proposal, PhD proposal. He has passed both. What is remaining is his dissertation thesis and the presentation of that thesis.
Okay.
Apart from that, he was required to complete 90 credits and he's completed 92. So our question is, can he change to F1 from H1 and then be able to apply for OPT?
First of all, for OPT, it is my understanding you need to be in F1 for 2 full semesters.
2 full semesters of F1 status?
Yes, before you can apply for OPT. So you may want to talk with the DSO, the designated school official, see if some kind of CPT option exists, and if also remember you've got to be a full-time student. You cannot be a part-time student. So check with the DSO whether that's possible. This is really an issue that only school can resolve for you.
Okay, so we need to contact the schools to get the answer for this question.
That is right, the DSO, designated school official.
Thank you so much for your time.
Oh, you're welcome. You're welcome. Good luck. Okay. So once again, Tampa, Florida. Any questions? You had your hand up. Okay, last call. Anybody has any question, press *5 on your phone. *5. Somebody just logged in from India. Not sure if they have a question. *5. Press *5 on your phone. Okay. Yeah, India has a question. Yeah, India, go ahead, please.
Hello.
Yes, go ahead, please.
Yeah, my name is Anil Gupta. I'm calling from New Delhi, India.
Ji.
I have currently a B1, B2 visa in the US in 2018. And I wanted to know the best.
Yeah, go ahead, please.
I wanted to explore the opportunity on the EB5 route in terms of investments in the US and what is the process and what are the norms for that?
Gupta ji, you have to make available between 560, 70, somewhere in that neighborhood, or $1 million, $5,000, $10,000, $15,000, somewhere in that neighborhood. And the money has to come from legal sources. It can be borrowed money, it can be gifted money, it can be earned money, and depends upon how you want to do it. If you want to make the investment yourself, you can invest $500,000 in a high unemployment area or a rural area, and over a period of 2 years create 10 American jobs. Or you can invest $500,000 in a pre-approved investment scheme. It is important to understand the investment scheme is only approved by the government for immigration purposes. There is no guarantee that these people are not going to run away with your money. Okay? So you have to do some homework and make sure you're not going with a fly-by-night operation. If you want to put $1 million, you can put anywhere in the country and again create 10 American jobs. There's another option where you can actually take over a distressed business which has lost about 20% of its value in the last couple of years. But again, you have to preserve the jobs that were already existing in that business prior to your takeover, and the jobs have to be 10 at least. Okay, so that in a very nutshell, very small bird's eye view is the EB5 investment option.
Okay, and does your organization sort of assist in choosing the right investment opportunity, or we need to do it ourselves?
Gupta ji, if I choose investments for you, you will be losing money day and night. I am not an investment advisor. In fact, when people start talking numbers, I start falling asleep. So I'm not very good with any kind of investment analysis. No lawyer is, unless they have some kind of specialization in investment analysis. Even then, there's no guarantee. So, you know, what anybody can do is you can ask around. Even we can give you references of the investments our clients have used. But that does not in any way guarantee them to be good investments or non-risky investments. It simply means other people we know have used them. We have processed papers through them. But tomorrow, because the investments are based upon projects, the same investment, typically they'll have 20 projects under the same investment scheme. And one project could be good, the other one could be bad. So there's no way for us to assess. That's just not our expertise. Short answer, no, we cannot assist in evaluation of investments.
Okay, great.
All right. Anything else I can help you with?
Yeah, I think I'm pretty happy, and I'll definitely write to you.
Please, you're welcome to. Good luck, Gupta ji.
Thank you so much.
Okay, so we have 2 more hands. Florida, you're still up, Florida. Okay, Campbell, California, go ahead, please.
Yeah, this is regarding question number 6. So how long I can hold back on H1 if I doesn't want to take the H1 this year? and how long I can hold back on H1 and take that back again if I want to take in next year or something.
Okay, you are the L1 to H1, right?
Sorry?
You are the gentleman who went from L1 to H1.
Yes.
Okay, well, here is the very interesting law. Now, there is the employer side and there is the employee side.
Okay.
As far as the employee side is concerned, you can hold off joining the employer for 3 years if you want, and you will not be subject to the quota. Okay. However, the employer is required to start paying you within 60 days if you are in the United States, or whenever you report for work, whichever is earliest. Okay. So the employer has certain liabilities that the employee does not have. Okay. Now, the good news is, as far as we understand, and you can double check that with USCIS, USCIS says if after October 1st, not before, if you revoke your H-1B before October 1st, you are still subject to the quota. But if the H-1B is revoked after October 1st, they do not consider you to be subject to quota for the next 6 years.
Okay, so that means I can pick up in the next 6 years whenever I want it.
That is correct, but please double check with USCIS. They change their mind more times than anybody else I know. So this agency is not very reliable. Okay?
Yeah, understand.
All right, guys.
Thank you.
You're welcome. I think we have covered everybody's questions. I have a slip here from Anna. She says they are calling USCIS again right now. So the gentleman who was holding for an answer from Anna, just contact Anna back again. That's Anna@immigration.com, ANNA@immigration.com. Remember, Anna is a paralegal. She's not a lawyer, but she will, of course, double check with me before she responds to you. Double check with her. They are calling USCIS again to confirm. I know that they are wrong unless they give me something more than just the word of a frontline USCIS worker who tells me, oh yeah, even though your H1 was approved more than 6 years ago, you are still not subject to the quota. That's just wrong. Okay, but we'll double check. We'll see how it goes. All right, folks. Well, good talking with you. It doesn't look like we have anybody else. I will see you again in 2 weeks. And thank you for this opportunity to be of service to you and to be able to talk to you. Every other Thursday at 12:30 p.m. Eastern Standard Time, we host free community conference calls. Everybody is welcome to join. Some people post questions ahead of time. You can take membership in our forums. All of the details are there on our website, immigration.com. You can take membership ahead of time, and it's instantaneous. It happens right away. And post your questions beforehand, or you can just log in. The phone number and all are provided: 202-800-8394, 12:30 Eastern Standard Time every other Thursday. We have free apps for both Apple iOS platform for your iPhones and iPads, as well as for Android. Just look for immigration.com, the period dot, and the application should show up.